So, Mr. Deacon, I've got a handful more questions for you. Can we start by putting up on the screen WITN 4436004? This is the memo we looked at earlier this morning of the 5th of August 1999. And this is a question relating to the copy list. It's copied into Mrs. Trowers of solicitors. And the same point is made in relation to that other memo that we looked at this morning of the 15th of July 1999. And the question is this: why were these initial briefings copied to Mrs. Trowers, a solicitor? From the start of your tenure, was the issue of contaminated blood scandal viewed by officials as a matter which had potential legal ramifications if it was to be looked into more fully?
I think the short answer to that is yes, even without the end of your sentence there, if it were to be looked in more fully. I think it's probably just, I'm guessing, but as a statement of fact, I suspect that it would have been viewed as an issue that that legal eyes would see at any time. And I've paid closer attention, actually, to the distribution lists in the context of looking at some of these papers in the inquiry, and I'm aware of some of the questions and concerns that people who have, people have been affected, I think core participants, if that's the best way to refer to people in this context. I've seen some of the questions that have been raised. In this instance, having a legal person on that distribution doesn't particularly register with me as signalling any more than it's seen as an issue where there are legal issues. There may be other times where I would think, why? But I know that people have asked, why were there lawyers in the room? And that's often the practice for a lot of issues, even if there isn't litigation, even if there aren't things being contested, there's just it's often the case. I don't think I should say any more than that about lawyers being in the room, but in this environment. But genuinely, I didn't. Well, I hope I've answered.
The next question also relates to this document. So if we could go over, please, to page 2, and this is a bit we looked at earlier, the bottom of page 2, we were looking at the lines to take from this, and then if we could go over to page 3, and it's the first paragraph there: the action taken by the NHS in Scotland in the 1980s to ensure the safety of blood products administered to haemophiliacs do not suggest that there was any negligence on the part of the health service. And it's the reference there to negligence. And we see that again in later documentation. So we saw it in your press release after the internal investigation. The conclusion you drew was no negligence. And the question is, why was the focus, even from this early point, and we see it through the documents, on the question of whether there'd been negligence? Was that not a matter for the courts, and the government should have been looking at something different?
Again, I'd be cautious about making a general comment for all the reasons I've said earlier about being so far away from some of the discussions now and some of the precision around it. But there is one comment maybe of some precision that I can make, albeit with a slight caveat in case my memory's playing tricks on me. But that word negligence, and when I say memory, this isn't thinking about 20 years, this is just thinking back to when I wrote my statement, I'm afraid. But I repeat it in my statement because it was the phraseology that was put in consistently in reports to me on the issue, including in the previous page, I think, actually, in this submission.
We look at page 2.
Yes, please, thank you. Or the previous page, sorry.
Or page 1.
Many there were.
It's at the top of page 2, I think.
And it's also on page 1. Paragraph 2, at the bottom of that paragraph 2, our advice, it starts as being that blood transfusion services were not negligent in administering
No,
building documents?
the point, without hunting through the document, the point is that I think it's in that submission, I'm sorry, I'd need to focus on it better to find it, where the official commentary was along the lines of the Haemophilia Society are claiming negligence on the part of ... And as I say, I think that phraseology has worked its way into my submission as well. And I think subsequently, when I was looking in more detail, I think it's a moot point. I don't think the word features in the Haemophilia Society release on this specific issue. Again, I'd need to look at it. And I think it's a moot point whether that this phraseology, they seem to be suggesting negligence or words to that effect. Here we are, first paragraph actually. The haemophiliacs appear to be claiming negligence by the NHS in Scotland, as it was referred to then. So I would agree, and I'm aware of the point, the question that you raise, and I think it would have to be for others to answer why that phraseology and terminology had become so embedded, maybe.
And the next question arising from that is that these assertions that are being made about no negligence and so on by officials in the documentation, is that something that and we see you drawing that conclusion yourself after the internal investigation in your press release, is that assertion something you adopted without question, or did you probe this conclusion? So we see in the documents, as you've just discussed, reference to negligence, and we saw in your press release after the internal investigation you drawing a conclusion there was no negligence, and the question is whether or not you adopted this assertion from the civil service that there was no negligence, or whether you probed it and came to that view yourself.
Oh, I probed a lot of things. Whether they were the right things, I don't know. But see, in my non-lawyer's head, right, and I realise that the terminology is really important in lawyers' heads, but in my non-lawyer's head, in all honesty, and this includes looking at the points that the Haemophilia Society have raised at various points and in their submissions to the executive and so on, I think there has been a lack of clarity, let's just say, sometimes about whether the debate is around fault and causation, or whether it is around, some what might be termed more in the space of the sort of moral question and so on. And I think, if I may say so, I think I've thought a lot about this point about how you resolve and take issues forward, as you've gathered and cross-referred with other examples where I feel it's been possible to do that. And I think by the time I was engaged in this, I think there had been so much kind of compound articulation around this. In other words, layers of articulation, not just in government's part, I may say, but in politicians and the points that were raising on different sides, that I think I just think the further you get away from when something has actually happened, the more messy all of that becomes. And so for me, when I look back even now, and I look at all sides, when I look at MSP's questions, of which there were lots, MSP's correspondence, of which there was lots, debate in the chamber and in committee, campaign materials, I just think by that stage, everybody was being pretty fuzzy and because I understand why those campaigning were trying to get some movement, so you look to different, ways that you can do that, but then it adds to the fuzziness, and then government and others will start, fighting something over there instead of over there, and I just, I'm sorry, I've moved quite far away from the question that was asked, but if I put it finally, just in my, as I say, layperson's terms around this specific point in time and the specific issue raised, it was part of my thinking, rightly or wrongly, have they done something wrong here or negligent? my small n negligent? Have they been too, consciously too slow to act? Has somebody, been sleeping in the job and not actually sort of done something that should have been done? Has somebody not spent the money in something that should have been done? That was where my head was, rightly or wrongly.
Were you commissioning an internal investigation into the issue of heat treatment in the mid-1980s? Were you concerned about whether or not it was appropriate to ask officials who had presumably worked closely with those in SNBTS whom they were investigating to investigate their colleagues?
I think in the first instance, as I've said throughout and in my written evidence, yes is the short answer in the first instance. To take that to the next stage. Well, that's my short answer.
So yes, you were concerned about that.
No. Sorry, I thought your question was, is it appropriate? I think was.
Yeah.
Sorry, it was. Is it appropriate? I beg your pardon.
So, in answer to the question, is it appropriate? Yes. Then, yes, I think it was in the first instance, because you have to. There's some fundamental points here I think that are quite important about. I know previous public inquiries, like Phillips and so on, have said things about public administration, and I suspect this one will too. And I think sorry, that's improper for me to second guess that bit, but I think that, at the heart of some of this is that really interesting question about, how you avoid some of the groupthink we spoke about earlier, how you counter just close working relationships that even if people do act very professionally, that people aren't confident in. But then also, if you bring in independent people all the time, then often they miss other things that actually, people who are part of the system can see. And it's a challenge all the time in any form of inspection, regulation and audit and so on. So I think there is a truly interesting question. It does nothing to resolve what's gone before or not been resolved before. But I think there's a genuinely interesting question for the future about how you can build confidence in parts of, not just government, but particularly in the NHS. There's real issues here. In that first stage form of what would be termed an internal examination and inquiries, so that you don't constantly sort of reach for the external inspection. And to be fair, we do have, hierarchies and escalating processes in other areas, but actually in government, it's really muddy and messy. And I can understand why people don't have a lot of trust in that. From where I was sitting and I'm sitting still, yes, I do think it was appropriate in that context for that exercise at the time.
Did you ever meet people who were infected over the period that you were a minister?
I only had, and this sits alongside one of the comments I made earlier, I only had one formal meeting with the Haemophilia Society. And through a combination of lots of different things, which, yes, was being spread so thin across so many different areas and trying to meet and visit so many parts of the country, but which also I think became over time what I was alluding to earlier, which was probably getting closer to what might have been my official's mindset rather than where I started out, of just feeling we're not going to be able to have a constructive conversation here and move things forward. Then I think that stood in the way of me meeting more people who had been through this experience in Scotland. I had other chance meetings, as you do. I was in a very high-profile role at that time, and I was going all around the country, so there was kind of no hiding place for me. And I had other chance conversations as I went about the country, and of course also was representing a constituency. But I ought to have had more dialogue during that time, and that's something I've taken away from this experience.
After discovering the complexity of the issues and appreciating that it was realistically a UK-wide matter, Did you ever consider calling for a UK-wide inquiry instead of just a Scottish one?
No, and I think my because some of my wider views, I think, again, I would make a distinction between a statutory public inquiry and some other form of investigation. I think what I said earlier was if there was going to be some form of wider retrospective examination, then I think it would need to be done at a UK level. And that's what's happening through a public inquiry here now. I think at that time, I was more concerned with what we do looking forward. And yet you could never move forward because there hadn't been resolution about the past. So I hadn't got to the conclusion that you suggest there, and I don't know if I would have done. And I think I still would have been concerned about introducing further delay, but then nor did I think we'd be sitting here 20 years on.
Is it right to understand from that, and I think your earlier evidence, that it was your view that you couldn't have looked at the whole scandal, i.e. matters that were outside Scotland, if you had an investigation within Scotland, even though you were responsible for NHS in Scotland, with which the scandal sat?
Could I just clarify the first part of your question there? Sorry,
I've mangled that question. Let me just read it as it says. You said that it became clear that the Scottish issues were linked with all sorts of UK decisions and practices, and that it would be acutely difficult as a Scottish administration to look at all of that. Why couldn't you have looked into all of the issues if you were responsible for the NHS in Scotland? I think there would have been limitations of power, and there absolutely would have been limitations of resource. And I think it would be a serious question about, if you're going to respect the devolution settlement, even if you had the powers and even if you had the resource, I would really question the appropriateness of that. I think the area where no, I was just going to reinforce the point that I think the area where the UK-wide piece was so important, and the fact that, and it links to us trying to build these new relationships post-devolution as well, was, as I say, much more about looking forward. And if I could, I've touched on this earlier, and I know it's a long step removed from the question, but I've mentioned VCJD. I think I can't speak for other ministers of the day. I think we were very focused on the future in terms of a lot of blood services and supply issues at that time. And I think we were informed, to be fair. Well, I'll say I shouldn't speak for others. I think we were informed by what had happened before, not least to make sure that we took the right steps that we could do in our time to prevent there being further harm and suffering down the track. I think that was also linked with that question about how much to look back, how much you want your blood transfusion services to be spending time looking back when you actually need them to be looking forward. And that's just a further dilemma in all of this, I think. I'm going to return to the issue of the internal investigation. Now, Dr. Keel gave evidence to the inquiry, and she told the inquiry that the officials took at face value the information given to them about what was told to patients about the risks of non-A, non-B and results of testing and so on. That they took that information at face value. Were you aware that that was the nature of the fact-finding exercise which your officials had undertaken? I'm
sorry to ask you to go back again,
yes.
But did you say that She said in her evidence that that was the case.
Yes, she said she was asked questions about how the investigation was carried out.
As somebody doing the investigation.
Yeah, and she said the officials had taken at face value what Professors Lowe and Professors Ludlam had told them, had said to patients about those issues. And the question for you is, were you aware that that was the extent of or the nature of the fact-finding exercise which your officials had undertaken?
I think I've seen quite a bit, and more through the eyes of or through the papers of the inquiry, to satisfy me that there was some real and meaningful examination around this done in a range of different places. I think that particular example that you've given me, and if that was what was said in evidence, I think that kind of sits in a slightly different space, which is, it kind of comes back to my question about how far you drill and what you ask. And I don't, in the first instance, I don't necessarily see there being anything wrong with that being an approach at an early stage investigation or inquiry. I think then, and this is the point about getting facts out to the open, what you need to follow that through and make it meaningful is you then need to be able to deal with the next stage, which is when people say, wait a minute, that's not our account. And then you need to have a mechanism to then further test. And we only ever completed really that first step. So I think I'm not hugely critical necessarily of that being the approach that was taken in that first step, but it's how you work that through, and then when so-called facts are challenged or contested, or evidence is contested, how then you identify what's contestable. Because I think there was a degree or a level of information came out through that piece of work that hadn't been collected in one place previously, and clearly I've seen has been used by others and not contested, just around some of the issues around state of science and knowledge at the time and the sequence and chronology of events. I think into the terrain of what people were told, and particularly when you take that to the level of individual clinicians and so on, then, as I said earlier, clearly there's far more questions.
The evidence you've just given that within that first stage, that internal investigation, you didn't think there was any problem with not probing or testing the evidence of Professor Lowe and Ludlam. Is that the case, even though the patients were saying something different?
To answer just for myself in terms of a process point here, well, there's two things. One, if you've asked for evidence to be collected in something, unless it's your full-time job, frankly, you can't, be questioning every bit of that evidence, unless you're the person that's actually in charge of the inquiry and doing it for yourself or overseeing it. And that is not the role of a minister in doing these things. You put a process in place. You have to deploy people to look into these things. Yes, you can have touch points along the way and ask questions, but you can't, and I would argue you shouldn't be interrogating a lot of these points. I come back to the point that you need to be able to then have a way of testing and questioning further afterwards, which we never resolved in that time. I think is that sufficient to answer the question that's been raised? I'm sorry it's getting late and I'm forgetting what the start of the question was.
And then a follow-on question from that. As the issues about information given to them about non-A, non-B, the risks and and what they were told about their infections had emanated from patients who had said they had not been so informed, i.e. they took a different view. Do you understand how your conclusion that there was no evidence to support what they were saying in the report left them feeling they'd been disbelieved and dismissed?
I can see that with much more clarity now than I could at the time. And I think that's also a function of you know, I know I've heard some other evidence, not all, but I know you've heard every I think, I'm guessing every ex-minister that's been here has said there's so many different things going on. And I suppose I've said during that devolution period, and without a well-developed government machine, and with, you know, one deputy minister and so on, and trying to make progress across the whole raft of the way that we set the direction for the NHS in Scotland and so on, then there absolutely was a limit to how much I could question all these things. But again, I come back, because I'm really not in the business here of trying to make any excuses for me personally. I suppose what I feel with in relation to that specific question, my short answer would be yes, and I'm sorry that was the case. And I think taking things on face value at the time, with the available time to examine, to question, to challenge and so on that there was, then, you know, it was not practically possible. It was, you know, I talk a lot about the art of the possible, and there was a lot of things during that period that was the art of the possible in terms of moving them forward, and that doesn't mean you always did things as well as you would have liked. But I also, just off the back of that, just want to make another point that I haven't made elsewhere. And again, as somebody who's really interested in these things and has been over the years, there is so much about the way that the decision-making process works in government that is so defective. I mean, it just is defective. And, you know, all this bittiness of information and all the, you know, the departmentalism that sits in every, you know, I've worked with governments in different places and at different times. You know, all that departmentalism about everybody having to, you know, protect their minister and put their point over there, and, you know, and you're getting reports and things that have been through goodness knows how many filters and all that kind of stuff. The dysfunctionality of that, to actually get meaningful dialogue, discussion, and get to the truth, and to navigate the terrain that is different opinions of things, is just utterly ineffective. And I just think this is an example of just system failure of being able to actually address the needs of a group of human beings that have experienced awful harm and suffering and just not managing to do it. So I'm sorry, I've extrapolated what was a precise question into a much wider observation, but that's my conclusion.
And then the last question is in relation to the actions taken after receipt of the report. Why did you not meet with campaigners and/or the Haemophilia Society to explain to them the limitations of the report, the difficulties you'd experienced, your plan for taking things forward, and the fact that this was the first stage in the process, not the end of the road or the end of the story?
I wish I'd had more discussions at that point. I made that plain earlier. I think there was a difficulty about continuing the dialogue with the society at the UK level. But that, as I said before, and I'll say again, just was not a reason nor an excuse to not have more dialogue with people in Scotland that were absolutely at the heart of this.
So those are the questions I was going to ask from core participants. I'm just looking behind me. No questions from Ms Deacon's.
Well, I have no questions of my own. Ms Scott?
Sorry. Ms Deacon, have you got anything you'd like to add?
No, I think I've shared a lot of reflections there, and I'm very grateful for getting the opportunity to do it. And I hope, if nothing else, it's given people a sense of some of what happened along the way, however inadequate it might have been. But I would just say, I suppose, having said that, however slow, messy and inadequate, I'm pleased that in a Scottish context, I think, you know, we did manage to move things on, if not bring things to a place that they need to be brought to. Thank you.
Well, can I, for my part, thank you. You've given us quite a bit of information about the context in which you made the decisions and a lot of detail of your own thoughts around that. Thank you. Can I ask you just to stay there for a moment or two, because I have one or two things which I must say. They don't concern you directly. Ms. Richards, the first, I think, is to ask, as I always do, when, next, and who?
We resume our hearings in the week beginning the 12th of September. The first witness that week will be Lord Crisp, and we have a number of witnesses and presentations for that week which focus on Section 9 of our terms of reference, so issues in relation to candour, cover-up, openness and so on. Obviously themes we've heard with a number of witnesses, but we'll be focusing on aspects of that during that week. And then the second week in September, the 19th of September, we will be hearing the evidence of Professor Tedder, and then there will be some other witnesses to be added to the timetable. So if core participants and legal representatives keep an eye on the website in the course of August, there'll be some additions to the timetable then.
Thank you. Well, as I said, I have some important things to say. Until September, of course, the inquiry's work will continue. But I would like to speak to you about two things in particular. First, on the inquiry timetable, and then to update you on the question of interim payments. First, the timetable. The majority of recognised legal representatives for people infected and affected have asked me to put back the date when they have to submit written submissions to me from the 24th of October to the 23rd of December, with oral submissions to follow next year. They suggest next year starting on the 20th of January. There are good reasons for this request. They point out that to do justice to the evidence that we'll hear in September and early October, and to allow proper time for consultation with their clients, more time is necessary for the preparation of final submissions. They argue that this should enable more helpful and focused submissions and thus result in no loss of speed overall. And I accept that none of the participants wish to prolong this inquiry a day longer than is necessary, and I join them in that. Well, I'm going to accommodate that request, although with two slight modifications. The new deadline for these final written submissions on the evidence will be the 16th of December this year. 16th of December this year. That's a Friday. It follows that the time for oral submissions will also need to be moved, and these will now be heard during the weeks of the 16th, which is a Monday, 23rd and 30th of January, the weeks beginning on those dates. Second, interim payments. Well, as you know, on the 15th of July, I invited submissions from core participants and government bodies on whether I should exercise my powers to make a recommendation about interim payments. The inquiry received 15 submissions on this matter, all of which urged me to recommend that an interim payment should be made. In addition to those formal submissions, the inquiry received several hundred emails from individuals, which indicates the strength of feeling among inquiry participants. Having considered the submissions, as well as the evidence and report by Sir Robert Francis QC, I have today, in line with the requirements of the Inquiries Act, sent my report on interim payments to the Minister. I have disclosed it to core participants. In advance of my sending the report to him, he gave me the permission to publish it, and I should say that it's a requirement under the Act that I have the Minister's permission to publish, and he gave it to me. I have decided that my report, exactly as delivered to the Minister, will be published on the inquiry's website once these proceedings have concluded today. It is a report about interim payments only. As you read it, please bear in mind that the full scale of the evidence heard and read by the inquiry and the results of its investigative work can only be recognised in my final report. Please also remember I have no power to order interim payments. My sole power is to make a recommendation. It doesn't have to be accepted by government, nor does it have to be accepted in full. I set out to answer two questions. First, whether I should exercise my powers to make a recommendation that interim payments should be made. And second, I should say, I recommended that they should. The second issue concerned the scope of those payments, and this is more complex. Sir Robert Francis QC recommended interim payments because the payment of full compensation could not be delivered quickly. He made a compelling case that interim payments are needed now to alleviate suffering and further suffering, and I agree with him. And I'm obliged to recognise that the practical way to make payments swiftly is to do so through the current infected blood support schemes. And that's why I've decided to recommend that interim payments of no less than £100,000 are made to all the infected people and all the bereaved partners who are currently registered with the schemes and those who register between now and the inception of any future scheme. I know that that will be disappointing to some of you who may fall into neither category, and I apologise for that. I ask those who are disappointed to remember that this is not the end of the inquiry's work, and the question of compensation and its scope is not resolved in this short report on interim payments. I repeat, the interim report concerns only whether I should recommend interim payments. Finally, let me say this. I know that many of you follow the inquiry's work closely, but I'm conscious that being a participant in an inquiry can bring with it an emotional burden. The inquiry team will continue working away, preparing for the next hearings, but until we meet again in September, I wish you a peaceful and restorative break.